Welcome back to the channel, everybody. Thank you so much for joining me and allowing me to continue to be your daily advocate. If you're new here or you're not subscribed for any reason, please do me a huge favor and hit the subscribe button. Thank you to all of you who have been watching and following me for so long. It truly means a lot, and I'm glad that I can be this person.
Well, the next chapter in the XRP lawsuit is about to begin, as Ripple and the Security and Exchange Commission prepare for the next phase of their legal battle following the court final ruling on the deliberative privilege process, which ordered the commission to eventually produce emails and notes related to the 2018 Hinman speech. And John Deaton has taken to Twitter to provide some insight into what to expect. A prior statement from John Deaton indicated that the case would be finished in less than 90 days after Judge Torres affirmed the earlier ruling of Judge Ned Byrne. He said, "I still stand by that. However, I did not really consider Ripple insisting on summary judgment without the emails and documents. In hindsight, it makes sense. Moreover, if a settlement cannot be reached, John Deaton believes that the best case scenario for a ruling in late August. The worst case scenario would be just before Christmas because the judge would be sensitive to the 2-year anniversary." John Deaton tweeted about it saying, "The emails and documents are most relevant to fair notice. Ripple can win on a strict Howey analysis and, if they do, the court never has to decide whether Ripple received fair notice. I can now see there being no settlement and the parties let the judge decide through Howey." He went on to say that a settlement is less probable than the XRP litigation resulting in a ruling by a judge in the long run. In other words, view the fair notice defense as insurance. It is an issuance policy that kicks in if Ripple loses on a Howey application. Thus, I am leaning on no settlement and a decision by the judge. The timing of a decision depends on how long it takes Judge Torres to decide. John Deaton further explained that the Securities and Exchange Commission has much more to lose if Ripple wins on fair notice and will keep on delaying as much as possible. By focusing on a Howey analysis, Ripple removes the last bullet from the Security and Exchange Commission gun. I can assure you the Security and Exchange Commission would rather lose the case on a strict Howey analysis than on fair notice. If she rules Ripple lacks fair notice, most altcoins, traded for the last 7 years, have a blueprint for victory. If the court finds XRP not a security, it applies only to XRP. Well, Ripple could score big if John Deaton's prediction comes true. What do you think? Meanwhile, the Securities and Exchange Commission has asked for a 2-week extension to submit an objection to Judge Ned Byrne's decision not to revise her previous verdict on the deliberative privilege process. While this is not unexpected from them, which Ripple has previously referred to as gamesmanship. Well, the case of the Security and Exchange Commission versus Ripple has now reached the stage of summary judgment. Both sides are meeting to see if they can come to an agreement on the sequence in which events will take place. The Security and Exchange Commission filing highlighted that Ripple was aiming for first briefs by the middle of May, but the agency has made it plain that it needs additional time to complete the process. According to John Deaton, who remarked on what to anticipate in various results, Ripple may still lose the case, but it is conceivable that both parties may win in terms of technical and legal arguments, as both parties will agree on a list of stated irrefutable facts. Those stated facts may be sufficient to prevent the matter from going to a jury for a decision. If the parties are unable to reach an agreement, a jury is summoned to determine what really occurred. The jury will then look at the facts to reach a decision. Well, the explanation was provided by John Deaton using an example. He tweeted about it saying, "If the parties in a car accident case do not agree on what color the traffic light was, the jury decides. But if both parties agree the light was red, there is no need for a jury to decide that fact." Hence, Ripple and the Security and Exchange Commission could agree to all of the relevant facts. Deaton provided a hypothetical example, in which the Security and Exchange Commission and Ripple agree that in February 2013, Ripple sold an option for 1 billion XRP to investor B, valued at 0.05 per XRP, for $25 million. Judge Torres, applying Howey factors, could determine that on that day in 2013 investor B gave $25 million, an investment, into a common enterprise, which is Ripple, with a reasonable expectation of profit. B.C. Ripple explained all the efforts it intended to make to drive adoption and utility of XRP. If the above factual scenario was agreed to, the judge could find that a specific offering of XRP, an investment contract with Ripple, Security and Exchange Commission, wins. Ripple could still win because the judge applying those same factors decides ongoing sales of XRP by Ripple are not securities. Ripple wins. The judge should find that secondary market sales of XRP independent of Ripple are also not securities. Then XRP holders win. Well, John Deaton has recently predicted that the XRP lawsuit could end in August as a best-case scenario, and a settlement between the Security and Exchange Commission and Ripple is increasingly unlikely. But not all jury trials are the same and there could be different results. Also, a request for an extension of time to submit its objection to Magistrate Judge Ned Byrne ruling on the motion for reconsideration of the deliberative privilege process ruling has been filed by the Commission. Not only are they seeking an extension, but they are also trying to file additional privilege arguments with the court in the hopes of having the deliberative privilege process decision overturned. After demonstrating several times that it would not give up on this subject, it is now up to the court to determine whether or not it will comply with Security and Exchange Commission requests once again. Even Ripple Chief Legal Counsel Stuart Alderoty expressed displeasure with the Security and Exchange Commission insistence on the use of blockchain technology, saying that, "Imagine if in civil enforcement cases we also abided by the Brady Rule, which in criminal cases, requires prosecutors to share all information in their possession that could help, or even exonerate the defendants." At the very least, the Security and Exchange Commission should heed the admonition of its own chair that firms should not use lengthy privilege reviews to delay responding to routine document requests. Alderoty referred to the hypocrisy of the Security and Exchange Commission, which is precisely correct. And by April 29, 2022, the agency is said to submit a move reaffirming its claim of the attorney-client privilege, as well as a motion asking permission to redact specific sections of the speech documents on the basis of the deliberative process privilege. Well, the agency is requesting an extension of time to object to the January and April orders until 14 days after a ruling on the Security and Exchange Commission forthcoming application renewing its privilege assertions with respect to certain internal documents related to a speech given by a Hinman. Well, they are requesting this extension in the interest of judicial efficiency. The Security and Exchange Commission also said that the defendants, Ripple, are willing to go to summary judgment if a definitive determination on the Hinman emails and documents is not reached within a reasonable time. What do you think? Will the court grant them the extension? Make sure to subscribe and give us a thumbs up. Thank you so much for watching. See you in the next video. Kindly note that the prices of cryptocurrencies frequently change, so by the time you watch this video, it might have changed to a whole new value. The information provided in this video does not constitute investment advice, financial advice, trading advice, or any other sort of advice, and you should not treat any of the content as such. The content in this video is for educational purposes only and hence should not be considered financial advice. Do conduct your due diligence and consult your financial advisor before making any investment decisions.
So enjoy your day, everybody. I'm always here for you. Leave any comments or questions below and be sure to subscribe. But thanks, everybody. I really appreciate you. Enjoy your day, and I always have your back. So thanks so much, everybody.